With it on behalf of Ms. Crittenden. Ms. Crittenden, can you please state your name for the record?
Savannah Crittenden.
You're requesting an adjournment. You were just recently appointed.
And this hearing starts with an interesting situation. A new defense attorney has just taken over the case and hasn't received all the evidence yet, but still wants to talk about bond. Discovery is the collection of police reports, witness statements, and other evidence the defense needs to prepare the case. Since the attorney just got involved, they need more time to review everything. At the same time, they're asking Judge Simpson to let the defendant out on bond. That puts the defense in a difficult position. When deciding bond, the judge isn't only thinking about whether the defendant will return to court. The judge also has to decide if releasing the defendant could put anyone at risk. Watch what happens next, because the prosecutor is about to make serious claims that completely change the discussion.
Yes, Your Honor. I was just appointed yesterday, so I don't have discovery yet on this matter. However, when appropriate, I would like to address bond.
During the matter, July 31st, 2025, 9 a.m. Yes, that's the bond briefing.
Your Honor, it's my understanding that these alleged incidents allegedly took place at an extended stay hotel while Ms. Crittenden's apartment complex was under construction. She has before staying in that extended stay hotel, had not known, and I would argue still does not know, the alleged complaining witness in this case, has no reason to have contact with them. I'm still trying to determine whether the construction at her apartment complex is complete. But Your Honor, I think that given the circumstances, I'd be asking for a release on a PR bond with a DPS tether with potentially a no-go to that extended stay hotel.
Response.
Your Honor, we would ask that the bond continue as set until the next probable cause conference date. The defendant was under investigation for criminal sexual conduct with a minor. That investigation was furthered for other information to be obtained. Ms. Crittenden was advised not to have any contact with the minor or his father, although there was no bond condition. She immediately went back to the hotel, had contact with the minor and his father. The police had to be called. The police came out, instructed her not to have contact with the minor and his father. The police left the hotel and were dispatched back again. She was having contact with the minor and the father and making arrests against the stalking charges. So we would ask that the bond continue.
The prosecutor's response creates a big problem for the defense. They are not simply asking the judge to deny bond. They claim the defendant was told not to contact the minor or the child's father, but allegedly ignored those instructions. According to the prosecutor, police were called, warned the defendant, left, and then had to return after more contact happened. That kind of behavior is something judges take very seriously. A personal recognizance or PR bond allows someone to be released without paying money as long as they promise to follow the court rules. But if someone is accused of ignoring warnings, the judge has to decide if more bond conditions would really make a difference. What do you think? If someone is warned once and police have to come back again, would a GPS monitor and a no-contact order be enough, or should the bond stay the same?
And Your Honor, if I may,
Yes.
Again, I just want to make sure it's clear. The CSC allegations, it's the same complaining witness as in the stalking charge. And again,
I get that.
So I just want to make sure that was clear, Your Honor. And again, I don't believe she has any reason to have contact with them. And I think a GPS tether with a no-go.
But as I understand, she was told she was under investigation for a CSC, told not to have any contact with this specific individual as well as his father.
And she denies those allegations, Your Honor.
Understood, but the allegation is that then the police were called back twice after she was informed of that, and that there were threats, which, as Ms. Reiser's indicating, have led to the stalking charge. I'm actually, given those allegations, surprised that her bond is set so low. Motion for bond reduction is denied.
Thank you, Your Honor. One more thing, Your Honor. I apologize. I was hopeful that Ms. Crittenden would be released and we could have an afternoon spot on the 31st. I do have a conflict in the morning.
You can talk about this. Well, it's going to be in the morning.
Right. No,
Put it on the 7th.
that's what I'm asking for, Your Honor.
All right. Probable cause conference, August 7th, 2025, 9 a.m. Bond will continue. Motion for bond reduction having been done.
Thank you, Your Honor.
What are we doing? Sir, Mr. Dick, he's still muted.
Yeah.
Why is he wrong? Oh, there he is. Sir, can you state your name, please?
Ibrahim Jakaite.
Okay. What are we doing?
In the matters that I represent, Mr. Diakete on 1232 and 1233, we will be requesting a set for a preliminary exam. To my knowledge, all discovery is complete in both of those cases.
Same with 5153.
You want an exam set?
Yes, Your Honor.
The courtroom then moves to another case. At first, everything seems routine as the court schedules a preliminary examination. Discovery appears to be complete, and everyone is discussing dates. But this step is important because a preliminary exam decides whether there is enough evidence for the case to move forward. When the defense asks to schedule the exam, it means the case is not being resolved today. Judge Simpson makes sure the schedule works and keeps the case moving. Once the hearing date is set, the focus quickly shifts back to bond. That happens often in court. First, the judge handles the legal process, and then the fight over the defendant's release begins. As soon as bond is mentioned, the atmosphere can change very quickly.
So,
People have their witnesses available the 29th.
We'll do our best, Your Honor.
Preliminary examination will be set in person July 29th, 2025, 9 a.m. before Judge Washington.
And Your Honor, when appropriate, my client would like me to address bond.
Go ahead.
Yes, Your Honor. Mr. Diakate would like me to request a release on tether. He does not reside at the same location as the complaining witness in the 1232 case. Prior to incarceration, he began working full-time as a caregiver. He'd like to be able to return to that work. He has no reason to be in contact with the alleged complaining witness in this case. No children in common, no residents in common. He does have his own transportation and will be able to return to court. He does have ties to the state of Michigan as he has family who resides within the state in different cities. So he'll be requesting a tether with a release on tether. Personal reconnaissance bond for release on tether in his cases.
Your Honor, just two things on my case. I'm trying to figure out what the bond is. Does your record show what the bond is on the 23 case?
The 23 case bond is 1,010%.
All right, thank you, Judge. I would just echo that, Judge, request for bond. And again, this is a 23 case that happened in the jail.
Response?
Your Honor, I would object to any modification of bond. This defendant is looking at 3 cases here, and I'll go through each one by one. In his R&O case, he is an officer tried to stop the fight and told the officer that he was going to kill him when he got out of jail. At his next case, he was throwing rocks at someone's windows. Officers arrived, saw a motorcycle leaving, confirmed it was the defendant, and a pursuit began where he reached speeds of over 100 miles per hour in a 45-mile-per-hour posted zone. He was caught after the motorcycle had stalled, and the motorcycle turned out to be stolen.
This is where the bond request becomes much harder to win. The defense argues that the defendant should be released with a GPS tether, saying they have a job, family support, transportation, and no reason to contact the complaining witness. Those are common reasons used to request a lower bond. But the prosecutor responds with several serious allegations. They mention threats made while in jail, rocks being thrown, a motorcycle chase at more than 100 miles per hour in a 45-mile-per-hour zone, and a stolen motorcycle case. Instead of looking at one incident, Judge Simpson is hearing about what the prosecutor says is a pattern of dangerous behavior. At this stage, bond is not about punishment. It is about protecting the public and making sure the defendant
And
returns to
then in his
court.
third
With
case,
allegations
the
like these,
victim who
a
were working
GPS
together
tether becomes much
had a
less
dating
convincing.
relationship. An employee at that restaurant called 911 to report that the victim had been dragged from the women's restroom, kicking and screaming, to a car, and the colleagues at work had saw visible scratches on her face. And after being put in the car, the defendant then drove away, and the victim jumped from the car, and officers found her in the middle of the roadway. I also wanted to report that he has a previous DD conviction from 2023, and he currently has hold from Delta County with bond denied. So I would be asking that bond remain as set in this case, Your Honor.
Anything else?
No, yeah.
All right.
Nothing from me. Nothing
Given
from
all of those circumstances, motion for bond reduction is denied. Bond will continue in all three matters.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case.
And good afternoon, Laura Yagi, Assistant Public Defender, with on behalf of Ms. Hill. Your Honor, I do have a green sheet. I apologize. I am seeking an adjournment for further discussions regarding the case.
In no objection, I did want to address bond.
Probable cause conference, August 7th, 2025, 9 a.m. Yes, that's the bond.
Simply wanted to request, there is no testing order whatsoever on this file. I provided the court, you may have the hard copy of Ms. Hill's. I think it started with Cho Balloon, she may now be on scram or vice versa in her circuit court case. I just wanted to ask that we have an order here to accompany that so that we get those results, because currently they're only being sent to 27.
Oh, you guys don't get them. I get them because of the game, but I got you. You're on a scram now. Right. When did you go on a scram?
The next case involves a different bond issue called scram monitoring. A scram device is used to monitor alcohol use. The problem here is not whether the defendant is wearing the device. The issue is whether the test results are being sent to the correct court. That may sound like a small detail, but it is very important. If the court is not receiving the results, it becomes difficult to enforce the bond conditions. Judge Simpson quickly realizes the solution. Since the defendant already has a scram device, there is no need to add another one. The court simply needs an order connecting the monitoring results to this case. There's also a light-hearted joke about running out of room for another device, but behind the humor is a serious point. Many defendants have several court cases and multiple supervision requirements at the same time.
They put it on me before I got out of jail, July 8th or 9th.
All right. What I will do is I'll continue the defendant's bond, and we'll order a scram tether on this case. We don't have to put another one on.
Thank God, we're not a space.
What do you say?
We're not a space.
We got two left, so we can put one on each leg. We've done that before.
Your Honor, I'm so sorry. I'm just asking for civil standby. I think it was an oversight at arraignment, but we just need a civil standby for her to get her belongings.
To do what?
For her to get her belongings from her residence. She's been evicted, but it is the location that she's not allowed to go back to. But she was told that she could get her belongings with a civil standby. And for some reason,
I don't need to order a civil standby. You called me.
They wouldn't come out when I tried to do that. I said I had to be ordered by a judge. I'm not allowed on the property.
So I don't know if
the Sheriff's Department told you that?
Yes.
If I scream loud enough, is that an order? Really? I've never. Ms. Yagi, craft an order.
Okay.
That's not how that works.
I was going to say, I'm happy to just send them JIS if the court just indicates like, okay for
civil order. They want an order? Do an order.
Got it.
People out of room, I'll put a big signature on it.
Thank you, Your Honor.
All right. Thank you.
Roba Hendon. I am here with and on behalf of Justin Hodge. Can you please say your name for the record?
Justin Paul Hodge.
Thank you.
Your Honor, we would like to set preliminary examination at this time,
All right. Is all discovery complete?
to the best of my knowledge.
All right. People have their witnesses available the 29th.
Try our best.
Preliminary examination in person, July 29th, 2025, 9 a.m. before Judge Barr.
And then, when appropriate, we would like to address bond as well.
Of course you will. Go ahead.
Your Honor, my client asked me for contact with his 2 children to be reinstated. He advises that he would not need to be in contact with the claiming witness in order to do so.
Response.
Your Honor, we would object to any modification of bond. The defendant was on probation when this case occurred for another domestic violence case in Wayne County. And he's currently being held out of reign for that. He currently has a hold out of reign for that DV, with bond being set at $1,570. And this current case involves the defendant having an argument with his girlfriend, taking her phone and smashing it, and his admitted to throwing the phone. So at this point, we believe bond is set as appropriate.
Were the children there at the time?
They were.
They were present at the time of
The 2-year-old was present.
the 2-year-old. So one of the children was there. Any other?
No, Your Honor.
All right. Motion for bond modification is denied at this time. Bond will continue with the conditions. Thank you.
The final case follows the same pattern. First, the court handles scheduling, and then it considers bond. The defense asks Judge Simpson to allow the defendant to have contact with their 2 children again. They argue there is no need for contact with a complaining witness. The prosecutor disagrees, pointing to a previous domestic violence probation case, a hold from another county, and new allegations involving an argument, a broken phone, and children who were present during the incident. After hearing both sides, Judge Simpson denies the request to change the bond. The current bond conditions will stay in place. The lesson from this hearing is clear. Bond decisions are based on risk. A job, family support, and proposed conditions can help, but serious allegations, repeated violations, domestic violence history, active holds, or children being involved can quickly outweigh those arguments. If you enjoyed this courtroom breakdown, leave a like, share your thoughts in the comments, and subscribe for more real courtroom analysis.